Yes, Mr Costello.
Commissioner, the next witness is Terence Paul McMaster.
Mr McMaster, would you prefer to make an oath or make an affirmation? Affirm the witness, please.
I solemnly and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr McMaster. Do sit down. Yes, Mr Costello.
Your name is Terence Paul McMaster,
That is correct.
and you are the sole owner and responsible manager of Dover Financial Advisors Proprietary Limited.
That's not correct. There are 3 responsible managers. I'm just one of them.
You're the sole owner and one of 3 responsible managers
Correct.
of Dover Financial Advisors?
Correct.
Thank you. And your business address is 71 Tulip Street, Cheltenham in Victoria?
That is correct.
You attend today pursuant to a summons to appear issued by the Commissioner.
That is correct.
Do you have that summons with you?
I do.
I tender that summons.
Exhibit 2.235, summons to Mr McMaster.
Mr McMaster, you've made a witness statement dated the 10th of April this year.
That is correct.
Do you have that witness statement
I
with
do.
you? I tender that witness statement.
Witness statement of Mr McMaster of 10 April 18 is exhibit 2.236.
Mr McMaster, you, aside from your work at Dover, also practice as a financial advisor
I do.
and as an accountant.
I do.
And you do that in your capacity as a director of the firm McMaster's.
I do.
Do you also practice as a solicitor?
I do.
And do you do that in your capacity as a director of McMaster's?
No, in my own capacity.
In your own capacity. There's a law firm known as McMaster's, Lowe and Drawrus. Are you a member of that firm?
No, I'm not.
You practice as a sole practitioner.
Yes, I do.
I see. And McMaster's, that's an accounting and financial planning firm,
That is correct.
and that's co-located with Dover at Cheltenham.
That's correct.
And is your law office co-located with Dover at Cheltenham?
Yes, it is.
And is the office of McMaster, Lowe and Drawrus also co-located?
Yes, it is.
Am I pronouncing the last name in that firm?
Andreas.
Andreas, thank you. How much of your time is taking up with running Dover as compared to performing your other professional duties?
At least 90%.
90% of your time is taken up
Correct. Increasingly so.
running Dover. I see. At the time of your statement, Dover had 408 authorised representatives, which makes it one of the larger licensees in the country,
That is correct.
well within the top 20 licensees by number.
Well, I'm not certain. I believe at the moment it would be in the top 10 by number of advisors.
Did you say
I'm
you'd be in the
sorry,
top
Dean.
10?
I believe it's in the top 10 by the number of advisors.
In which states does Dover have authorised representatives?
Each of the states and
All-
territories.
All states and all territories?
Yes.
Thank you. Now, as I understand it, Dover's model is considerably different from that of other licensees in some material respects that I want to take you to. The first is the way Dover charges its authorised representatives.
Yes.
Before I come to what Dover's practice is, what do you understand to be the industry practice, if there is one, in respect of the charging of authorised representatives by licensees?
Almost always the volume of product will be a variable in the fee computation.
I see. And Dover doesn't adopt that practice, it instead charges a flat fee.
That's correct.
What is that fee?
$20,000 a year, including professional indemnity insurance.
Is it $20,000 a year, including professional indemnity insurance, per authorised representative?
Per authorised representative. In the case of a second or subsequent representative in the same organisation, it's reduced to $12,000 per second and subsequent. $20,000 for the first, $12,000 for each after.
I see. And is that the only fee charged to authorised representatives by Dover?
Almost so. Some advisors will use a paraplanning service we provide, and they pay a relatively nominal fee for each SOA that the paraplanning service provides. It's normally $300. It can increase for more complex statements of advice.
This is a paraplanning service provided by Dover.
Correct.
And does it have its own name?
Yes and no. I'm not being evasive. There is an entity called Simple Paraplanning, and I had 70% ownership, or actually 85% ownership of that. and one of my colleagues at a time had 15%, but now I'm 100% of that. And as a practical matter, the two entities are interchangeable. Simple Paraplanning does not have a significant income stream, and the staff of Simple Paraplanning are actually our compliance staff.
Dover's compliance staff.
Correct.
So Dover's compliance staff, aside from doing their ordinary compliance activities, also will draft statements of advice on request for Dover authorised representatives.
That is correct.
And they do that as officers, agents or employees of Simple Paraplanning, a separate entity. Is that how it works?
Because it's the same beneficial ownership, it's quite blurred. The answer is yes.
Yes, so it is a separate legal entity. But
yes, it is.
And I might come back to Simple Paraplanning a little bit later, but staying with the fees Dover charges for now, why did Dover decide to structure its fee arrangements with authorised representatives in the way you've described?
To avoid Dover having a financial interest in the outcome of an advice.
In the outcome of an advice?
Correct.
You mean by reason of a fee related to a product?
Correct.
I see. And could you explain to the Commissioner what Dover 365 is?
Dover 365 is favourable payment terms introduced in 2015 where there is a 12-month lag in the payment. So
sorry, I couldn't quite hear that.
There is a 12-month lag in payment, so that an invoice rendered in, say, July 2018 won't need to be paid until July 2019.
That is an invoice rendered by Dover to an authorised representative.
Yes.
Say the $20,000 fee.
Well, it's monthly. 20,000 divided by 12 per month.
Per month. But it's deferred for 12 months.
Payment is deferred by 12 months.
I see. And is that the case in respect of all authorised representatives?
Yes, it is.
I see. Another difference in Dover's business model is that it doesn't require its authorised representatives to use any particular software. Is that right?
That is correct, but we have our own in-house software which accounts for about 75% of the statements of advice.
This is software developed by Dover?
Correct.
And authorised representatives can use that software if they'd like?
Yes, if they prefer. We encourage it because it makes the review process simpler and faster.
What's that software called?
In our jargon, we call it RODO.
You call it what?
RODO.
How do you spell that?
RODO.
And when was RODO first developed?
It was evolutionary steps. It probably came into its current form about 2 years ago.
And before that, authorised representatives used whichever particular software they chose to use to generate statements of advice?
That's correct. My preference was Word.
I see. And does RODO use Word?
It produces a Word document at the end of the process.
Does it require the completion of specific fields that then generate a Word document?
Correct.
I see. And in terms of the submission of statements of advice to Dover from an authorised representative, does RODO have any function in that, or are they provided by email?
The RODO software produces a Word document. It's been designed so that is actually a sufficient draft for most of the content of the statements of advice, but we allow the advisors to go further if they feel that adding in extra information is relevant and makes the SOA work better. They've got a Word document that they can use as a first draft for that exercise. The comforter is that the first draft is intact and compliant at that point. So they're making a good thing better if they start adding to it.
And when we'll come to the statement of advice review process a little later, but just so I can understand
Certainly.
the function of how it works now, when an authorised representative prepares a statement of advice using RODO, do they and they want to submit it to Dover, do they submit it by email or is it submitted through
They submit it by email,
Yes,
whatever email system they're using.
Thank you. Is Rodo used for fact finds?
No, I don't believe it is. There may be some functionality there, but the fact-finding has to be done separate, and I think there is some capacity for the fact-finding data to lead directly into the Rodo program.
Do you use Rodo when you're completing statements of advice?
Yes, I do, for the first draft.
And in return for the flat fee that Dover charges its authorised representatives, it supervises their compliance?
Yes, it does.
And Dover's head office is in Cheltenham,
Correct.
but it has another office in Vietnam, is that correct?
That is correct.
How many Dover staff, as opposed to McMaster's staff or McMaster's Low and Andrea's staff, are in the Melbourne office?
About 22, I believe.
And does it share staff with the other firms?
These days, no, except for, say, simple paraplanning. There's some secondment of Dover's solicitors to MLA from time to time.
Dover has its own internal solicitors.
Yeah, a lot of the staff are practising solicitors.
All right. How many staff are in Dover's Vietnam office?
28.
And what functions do the staff in the Vietnam office perform?
In general terms, functions that they can perform. So if they have the capability to do it, we prefer to do it there because of the obvious cost advantage. There are perhaps three main groups. One is the administration of the commission account. We treat the commission account in effect as a trust account. It's not strictly a trust account, but we treat it as if it is. And there are 6 staff who monitor the commission account daily and reconciling payments out of the commission account to statements of advice and other relevant documents as those payments occur. Fee disclosure statements in particular.
And do they perform any other functions apart from monitoring the
No,
commission
those staff are very busy on that task.
On the commission account.
It's a big task.
I see. I thought your evidence was that there are 6 people that monitor the commission account. Is that what you just said?
Correct.
And I thought that you told me earlier that there were 25 staff in the Vietnam office.
The commission account function is the first of the 3 main functions.
What are the other 2?
The second main function is 12 staff, all university qualified, well experienced, well trained, good at their work, who perform, if you like, file management tasks in respect of the draft, the SOA submitted for review. There, they will receive the SOAs in, they'll log it into our file management system. They'll do preliminary quantitative checks, such as making sure the fact find is correct, making sure we have extra documents to do with the best interest duty, to make sure that the best interest duty is, if you like, able to be proven, and certain other mandatory data, such as identity checks and things like that. So they do that, if you like, clerical task, and then they perform a further task where they do a preliminary review of the statement of advice. Now that includes literally checking that schedule on page 3 to make sure it adds up.
I see.
It's more of a quantitative testing, but because over time they've got good at what they do, I'm delighted to say they frequently flag issues, and they bring the issues to the attention of the Australian staff in the next phase of the review process.
And is what you've just been describing there, is that the third of the 3 tasks?
No, that was the second.
That was the second as well. All right. And what's the third?
The third is just general administration.
When was that office established?
It was established, in effect, about 10 years ago, and then about, I think, 3 years ago, we split. The original office was McMaster's, an entity set up under the Vietnamese law, and about 3 years ago, because of growth issues and space issues, we decided to physically move the Dover staff in that office out of that function into its own office with its own Vietnamese licence and legal presence under the Vietnamese law.
What's that entity called?
Probably something like Dover, Vietnam.
See,
I don't know exactly. I'm not being evasive.
No, and it's licensed under Vietnamese law.
Under Vietnamese law.
Not under Australian law.
Correct.
It's not a licensee for the purpose of
It's
the Corporations Act.
remembering they don't have a system that parallels ours. The closest I can call it is an agency.
I
You
see.
can give it a Western equivalent.
But it's not an entity that is
No.
licensed under the Corporations
I
Act.
don't. No, not all. In fact, interestingly, under the Vietnamese law, it's actually not allowed to make a profit. So, and it's only allowed to provide services to us. So it bills us every month, and we pay it, and the amount paid is equal to its costs for that month plus a small cash float, obviously. So it's not allowed to make a profit in Vietnam.
And was that office established for cost reasons?
Yes.
Mr McMaster, on the 15th of February this year, the Commissioner wrote to Dover inviting it to assist the Commission by identifying instances of misconduct by Dover or any of its authorised representatives. You're aware of that letter?
Yes, I am.
And Dover chose not to take up that invitation.
Yes.
Why was that?
It was phrased in terms of an invitation, which we took as not being in any way mandatory. An invitation doesn't require a response. And for no real reason other than that.
Are you aware that Dover is the only large-scale financial advice licensee that declined that invitation?
The word decline is strong. A better word is didn't respond. We just didn't realise that something greater was expected.
Well,
it was phrased in terms of an invitation.
I won't take it to you now, but I can later if you like.
Sure.
There was a response from your office that declined to participate.
Okay, fine.
Was that given at your direction?
I can't recall.
I see. We've spoken already a little of the Dover Statement of Advice review process, and I'd like to understand that process a little bit more. But at a general level, am I right to say that Dover's method of advice supervision is unique in the Australian market in that it reviews every statement of advice prepared by each of its authorised representatives?
It does review each statement of advice and similar document prepared by each of its authorised representatives. I believe it's unique.
When you say or a similar document, do you mean an ROA?
Yes, I do.
And could you explain what an ROA is?
The little brother of an SOA, subject to certain conditions. If there's no significant change to the original advice, rather than having to go to the trouble, cost and time of a full second SOA, you can do a shorter document called Record of Advice, which functionally achieves the same purpose. So an example might be, in the original SOA, a particular cash management trust was recommended, as an example. For some reason, that one wasn't implemented, but a very similar one was, say 3 months later. That change can be communicated to the client in a record of advice. You don't need to do the full statement of advice once again.
But Dover reviews those records of advice as well.
Yes, it does.
Thank you. Now, as I understand it, there have been some modifications to the process of statement of advice review over the years, but I want to begin by taking you to some compliance committee minutes that describe the process, because it might be a convenient way into the topic. Could I show you this document, please? It's DOV.0002.0001.0224. You can see there, Mr McMaster, on the screen. These are minutes of a compliance committee meeting of Dover held on the 10th of April 2013 and signed on the 9th of May 2013.
Yes.
And you're a member of the compliance committee.
That's correct.
And if we move forward 2 pages to point 226, you can see there there's a heading Dover pricing policy, and it says under that what the fee then was, and the 50% discount. And then under that there's a heading new insurance arrangements, and it says Terry advised the meeting that Dover continued to engage McMaster's Legal to review all SOAs and similar matters on a retainer of $3,000 per month. Just pausing there, what's McMaster's Legal?
That's basically me. And I think there was a corporate entity called McMaster's Legal.
I see.
Well, there is one.
I see. And that was you as a sole practitioner?
In effect, yes. There were some employees.
What type of employees?
Solicitors.
I see. And why was McMaster's Legal engaged to review statements of advice?
To add a third level of review to the review process, and to help the overall presentation of the statement of advice.
The overall presentation?
Yes.
Do you mean the formatting?
Well, if you like, the gravitas, the traction of the statement of advice, the fact that it has actually been reviewed by legally qualified people, then a third check by solicitors.
I see.
It's part of it.
You can see the next paragraph. It says the goal was to access the compliance skills and expertise of McMaster's Legal and its professional indemnity insurance policy.
Correct.
And if we can just quickly go to 0241, which is in the same document. You can see at the second half of the page there's a list of factors that caused the compliance committee to form the view that the current professional indemnity arrangements were appropriate.
Correct.
And you can see the 6th line in that list is McMaster's Legal PI professional indemnity insurance, cost agreements and payments for SOI compliance review in place. And it then says below the numbered list, Terry noted that all SOAs were being reviewed by McMaster's Legal for compliance, and that this effectively brought McMaster's Legal's PI insurance cover into play for Dover advisors. The meeting considered this strategy and resolved to continue it for the foreseeable future, but to monitor it as part of an ongoing risk identification and management strategy. Terry advised the meeting that a submission would be put to ASIC in August 2013 to reduce the amount of PI cover. Is part of the reason that is behind these statements that legal professional indemnity insurance is cheaper than professional indemnity insurance for financial advisors?
Yes.
And the statement of advice review process, by having McMaster's Legal do it, that is you, in your capacity as a solicitor, engaged your compulsory professional indemnity insurance that you're obliged to hold as a solicitor.
Correct.
I see.
Can I add to that, please?
Yes.
The relatively regulatory guidelines which deals with adequacy of compensation arrangements specifically refers to additional arrangements such as directors' insurance. It doesn't refer to solicitors' insurance, and says that that is one of the matters which should be considered when you're determining the overall adequacy of your compensation arrangements.
Thank you. Could I take you back to page 0226? And you can see a little further down the page there's the heading Advisor SOAs. Perhaps we can make that a little larger. Thank you. And it says there that Simon reported that he or another member had reviewed almost all advisor SOAs over the preceding 5 months. He was happy with the quality and believed they complied with the law and with Dover's specific requirements. Pausing there, Simon is Simon Lowe.
That is correct.
And is Mr. Lowe a financial planner?
No, he's a solicitor.
He's a solicitor. And who is Mr. Lowe's employer?
He was probably working effectively for Dover at that time.
I see.
It is 5 years ago.
Yes. And is Mr. Lowe still with you?
Yes, he is.
Is he still employed by Dover?
No, he's not.
Where is he?
He's now a 50% owner of the law firm McMaster's Lowe Andreas.
Thank you. And it says there that Simon reported that he or another staff member had reviewed almost all SOAs. Can you recall who the other staff members could have been at that time?
It would be, for example, Yin, who, looking at the compliance, at the top of the page 1, there was a list of persons who attended the meeting.
Yes.
And for example, there you'll see Yin. Yin's currently our compliance manager.
I see.
So she would have been involved in that process too. And there would have been other staff as well who weren't attending the compliance meeting, the compliance committee meeting, because they weren't on the committee.
Is Yin a financial planner?
Yes, she is.
Thank you. At this point in time, Dover had 127 advisors.
Correct.
The retainer to McMaster's Legal was stated on that page that I took you to earlier, a little higher up the page, as being $3,000 per month.
Correct.
That's $36,000 per annum.
Correct.
And if each of the 127 advisors prepared a statement of advice, adopt a conservative figure, once a month, that would be 127 statements of advice a month that required review by McMaster's Legal. That's 1,524 statements of advice in the course of the year.
Correct.
Now, on my maths, 36,000 divided by 1,524 gives an average cost per review of the statement of advice of $23 per statement of advice. Would you agree that $23 is not a lot of solicitors' time?
Yes, may I add to that?
Yes.
I was paying myself, so there's no need for it to be an arm's length payment that I'm aware of.
You may have misunderstood the intent of my question. It's simply that on what I would have thought is a highly conservative estimate of each authorised representative producing only one statement of advice per month, then for your time and the time of your staff in reviewing those statements of advice.
May I clarify? This is the third review, not the first or the second review, and the payment from Dover to, say, at that time McMaster's Legal, is a payment from 100% owned company to another 100% owned company,
Yes.
and it's not an arm's length payment.
Well, I think also there was another conservative assumption that I didn't state, and that was that if you counted solicitors' time at $150 an hour, say, then you'd have to review the statement of advice in less than 10 minutes, wouldn't you?
That is actually quite possible to do, because the statement of advice is expressed, the solicitors are reviewing it for best interest duty and appropriateness of advice. The average length of
Typically quite long documents, aren't they?
ours are around 5 pages.
You couldn't assess the best interest duty without assessing the fact find, could you?
If the SOA is prepared correctly, I believe you can.
Because the information in the fact find is set out in the statement of advice?
Correct. And we also have a series of reasons in. Remember that SOAs have evolved over time, but the current form of the SOA requires the author to specify why the advice is in its interests.
And it's your evidence, is it, that a solicitor could review a statement of advice and form a considered view on whether or not it is compliant with the various Chapter 7 obligations that you've mentioned in less than 10 minutes?
I think there's a little bit of words in my mouth there. It is possible in some cases to do that. And certainly, being quite experienced, if I'm asked to do it, I can look at this statement of advice very quickly and make a decision like that. The best interest duty, the appropriateness of the advice should be manifest from the document, not something hidden away in a worksheet somewhere.
I see. Is there still a retainer agreement in place with you as a sole practitioner
No.
to review the statements of advice?
No.
What's the process now for what you've called third
The
level
third,
review?
the third review.
We're going into a discussion of the current system. We might take that up after lunch, I think, Mr Costello.
Thank you, Commissioner.
May I ask you to be good enough to be back in time to begin at 2,
Seven.
Mr Master, 2 p.m. Yes, Mr Costello.
I have sworn evidence of a bank protection racket involving NAB, its lying lawyers and its shareholder presiding judges.
I think we have had this discussion before, have we not, sir?
Tax Commissioner
I'm
needs
sorry.
75 million will
Would
get
you be
to
good
the
enough to
bottom
be
of
quiet?
corrupt, unconscionable conduct.
Would you be good enough to be
You
quiet
and
and to
I
sit
have
down?
a public duty.
Please sit down.
I have a couple of statements for Ms Orr and for the Commissioner.
Thank you. By all means, send those by email to us and we will read them. Yes, Mr Costello.
Thank you, Commissioner. Mr McMaster, we were discussing the Compliance Committee minutes of the 10th of April 2013. The document ID is DOV.0002.0001.0224. And if we could go to 0227, please. Before we come back to this document, I just want to close off on what we were discussing before, Mr McMaster, about the retainer that then existed with McMaster's Legal. I think your answer to one of the last questions I asked you was that there is no retainer arrangement in place now. Is that correct?
With me?
Yes.
That's correct.
Is there a retainer arrangement in place with another firm?
Yes.
Which firm is that?
MLA lawyers.
And what's the nature of the retainer?
There's a payment every month.
Yes.
The payment depends on a number of things, including the salaries of staff seconded. So there's a reimbursement of their cost element in the computation. And I remember that we've actually got 50 or so staff. We have a CFO lady, and I'm not aware of the exact amount each month.
Is it volume-based or time-based in any way?
It's time-based,
Time
plus
of
a retainer amount on
a
top
retainer
of that.
amount plus the amount of the solicitor's time
Yes,
taken in reviewing the
Yes.
statement of advice.
yes.
And that is an arrangement with a firm that you're not a member of.
I have no interest in any form, shape with MLA lawyers.
Thank you. On the page that's in front of you, there is a heading New SOA Review Processes. And you can see in the second paragraph under the heading, it says advisors could send the SOA to the client without Dover pre-approval if they answer yes to each question in part 1 of the checklist. The SOA still had to be sent to Dover for retention. If the advisor answered no, Terry has to look at the advice before it goes to the client. Terry's a reference to you, obviously.
Correct.
And why would you have to check the advice and not Mr Lowe if there was a no answer to one of the questions in the table?
So that I'm checking it as the responsible manager.
You're checking it there as the responsible manager, not in your capacity as a sole practitioner.
Correct. The reason is that that table there identifies statements of advice which we believe are more complex for the reasons stated, and therefore we were giving them a higher level of review, and basically as the responsible manager I needed to approve each one of them
Yes.
on top of the normal review processes.
Thank you. Perhaps then we can quickly look at the table. So the heading reads, Part 1, if the answer to any of these questions is no, the SOA must be submitted to Dover for approval before it's sent to the client. And the first question is, does the advice involve less than $400,000.
Correct.
Does that mean $400,000 worth of assets?
It means most advices have a risk insurance component. Then many will have an investment component as well. And of course, you could have an SOA just for investment too. We drew a line in the sand and said, well, 400,000. If the amount is above 400,000, the figures are bigger. The matter's more grave. As a responsible manager, I had to see that SOA. It meant we were classifying the statement of advice as complex. I think in those days we called it contentious.
I see. I just want to put the question to you again because I'm not sure that I've properly understood your answer. The reference there to $400,000, is that a reference to assets being dealt with in the advice? Is it a reference to the amount that may be invested following the advice, or is it a different amount?
The second.
The second, the amount that may be invested?
Yes.
$400,000.
So a client may have a home and superannuation worth, say, in total $1 million, and then they might be investing $401,000.
Yes.
Because they're investing $401,000, that SOA would have to be reviewed by me as well.
But if they had $500,000 each in superannuation, that question could still be answered yes if they didn't have any other investments. Is that right?
Yes.
Thank you. The next question is the client conservative? What does that mean?
We have a criteria for it. Basically, we assume conservatism in attitude on the investor, and that means that the recommended investments as a starting point have to be conservative. We then ask the advisor to discuss the concept of risk and return with the client, and then in the statement of advice set out in a paragraph having regard to factors such as age, income, wealth, education, training, prior investment experience, whether we believe a reasonable financial planner would say that they should not be invested conservatively, but rather should be invested more towards growth at the other end of the risk spectrum in the classical analysis. And the client has to agree as well. So if we're not treating the client conservatively, if they're not conservative investments, they had, at that point of time, this is 5 years ago, they had to be reviewed by me as well.
The client came to a Dover authorised representative and said, I want to make an investment in a managed fund. I want a high growth option. Mm-hmm. Could that client be classified as conservative insofar as this table is concerned?
It would depend on the facts. If that client's critical criteria, I just enumerated them, suggested that a reasonable financial planner would agree that that client should be investing in high growth, we would treat the client as not being conservative. But if, for example, that client was a 62-year-old retiring bus driver with no previous experience in investing, without adequate education and training in the field, even if they said they wanted to invest high growth, our advice would be, no, you shouldn't do that.
Are you encapsulating within the question, is the client conservative, the statutory best interest duty?
A bit more than that, actually. It's basically, we don't like risk analysis questionnaires. The reason is simple. I went to an ASIC seminar and the presenter said that ASIC doesn't like them and prefers people to use other criteria as well as, if not in place of, a risk analysis questionnaire. So we require the advisor to consider the objective facts of the client's background, as I say, age, income, wealth, prior investment experience, education, training, and so on, when they're assessing the risk profile. And only if those factors, on balance, different circumstances, different weight will be given to each of them, but only if on balance those circumstances say that a reasonable financial planner would agree that it's high growth, can the advice be high growth? It's a reasonable professional test.
And it's a reasonable professional test that is self-assessed by the advisor who's written the advice.
Yes.
So the advisor who's written the advice forms a judgment about whether or not their own advice accords, on your evidence, not only with the statutory best interest duty, but with a higher obligation than that.
And then we read it, and the advisor has to be right.
Yes, but you read it after the advice has gone to the client.
No. I know that sentence is there, but we actually check them before they go to the client. And that's
These are the minutes of the
2013.
compliance committee that you sat on. They were signed on the 9th of May after the meeting. Is your evidence now that the minutes are inaccurate in that respect?
Allow me to read it. In that time, I confess to be a certain amount of uncertainty because, to the best of my recollection, they've always been checked before they go. But I agree that sentence there indicates that if they were conservative, they could go earlier.
There's then what I might describe as a more subjective question, the third question. If the client is not assumed to be conservative, have the reasons been adequately explained in the SOA? Again, this is an assessment made by the advisor who's written the statement of advice.
The advisor has to explain why they've chosen or suggested that the client has a particular risk return profile. And they have to explain in a paragraph or so why they formed that opinion. Then we test that opinion at the review stage to make sure a reasonable financial planner would agree.
That's not what this says. This says that the advisor, that is the authorised representative who's prepared the statement of advice, determines for him or herself whether or not the reasons have been adequately explained. And if the advisor forms the view that they have been and answers yes to each of the other questions, including the two I've spoken to you about, the advice can be sent to the client before it is sent to Dover.
This is 2013.
Yes.
And I will say, nevertheless, despite reading that, to the best of my recollection, they were checked before they went even then.
Well, how would you know?
As I said, to the best of my recollection.
But how would you know if they were sent to you before they'd been sent to the client?
We have a whole lot of checking processes in place for that. May I expand?
Yes.
The commission team, most of the SOAs will have an insurance component, which means there'll be a commission. When the commission amounts come in from the insurers, the payment due to the advisor is reconciled against the statement of advice. And if there's no statement of advice, the commission is not paid on to the advisor. So an advisor will not do what you're suggesting, that is send an SOA to a client without us checking it. Because at the time comes to be paid the commission, we will literally catch them out.
Well, what about a client in an ongoing service relationship where they pay an ongoing service fee?
Those payments are reconciled to the fee disclosure statement, so we verify it that way. But I'd be asking, what would the motivation of that be?
But a client that has agreed to an ongoing service arrangement with an authorised representative of Dover might require multiple advices in the course of the year. It might be the very reason they've chosen to have an ongoing fee arrangement. Do you agree with that?
It would be unusual. Multiple statements of advice in a year would be very unusual.
Be a complex client?
It would still be very unusual.
Would it be possible?
I can't think of one, actually.
You can't think of a circumstance where a client has received more than one advice in a...
No, you said a series of complex SOAs in a year.
No, I said a client who may be a complex client might require multiple statements of advice in the course of a year, and they may choose to have an ongoing fee relationship with a Dover authorised representative for that reason.
Well, it is theoretically possible.
And in those circumstances, if the statements of advice were not submitted to you, to Dover that is, before they were sent to the client or at all, you wouldn't know.
That is correct.
you'll see at the foot of the page there is a repetition of the statement that you've cast some doubt on, that in the case of non-contentious SOAs, advisors can send the SOA to the client before it's reviewed by Dover. Seeing that for a second time, does it cause you to reflect on whether or not that is an accurate representation of the process at that point in time?
Basically, at that time, I can see it there now, the review would happen basically as the advice goes to the client, if it was a simple statement of advice, not contentious.
Now, you've given some evidence earlier about statements of advice receiving review from lawyers.
Yes.
And at this point in time, that was you, but now that
And
is...
solicitors working for me.
And solicitors working for you. And now that is MLA.
MLA lawyers, McMaster's Low Andreas.
Yes. Is that right?
Correct.
And that's an independent firm separate from you,
Correct.
you've told us. Does the assessment of financial advice require particular training in non-legal matters?
Well, yes.
Do you accept that reviewing statements of advice prepared by financial advisors is not legal work as that phrase is ordinarily understood?
Yes. Well, actually, it's interesting because they're assessing the work with reference to whether it satisfies the rules in 961B(1).
And are lawyers qualified to do that, in your opinion?
I believe so, particularly when they're also financial planners.
But they're not all financial planners, are they?
Minna is, and the staff are.
All of them?
Maybe not at all times, but normally yes.
Well, your evidence earlier was that Simon Lowe was not, wasn't it?
I said Minna is.
Yes, but I'm just saying to you that your evidence earlier was that Simon Lowe was not a financial
Correct.
planner and is not, and he is listed in these minutes as one of the people that's reviewing the advices.
Correct.
And his firm, the firm of which he is a partner, is the firm that is currently engaged to review the advices.
Correct.
I see.
Just these minutes of the meeting of the Dover Compliance Committee. Mr Costello, are you tendering
Yes,
those?
thank you, Commissioner.
Minutes of the meeting of Dover Compliance Committee 10 April 2013, DOV 0002 0001 0224, Exhibit 2.237.
Thank you, Commissioner. Mr McMaster, I want to show you a different document. It's RCD.9999.0024.0018. Thank you. This is an article that you wrote in 2016 and is on the website of Dover. Did you publish this article anywhere else, to your recollection?
No.
All right. If perhaps the last paragraph, actually, could the next page be brought up next to that one? Can you see the last paragraph on the first page? Perhaps that could be blown up a little bit. This is an article you wrote about the Financial Ombudsman Service where you had unflattering things to say about it. And we might come back to other elements of it later, but there's a part of it that's relevant to the line of questioning that I'm taking you on now. You see there, you say, FOS is unique in that experienced and unqualified non-professional employees form opinions on what experienced and qualified professionals should have done, with the benefits of plenty of time and hindsight. Could you imagine the outcry if this happened in other professions, say doctors or architects? Sure, the FOS junior may have a law degree. So what? How does a law degree equip you to judge what a qualified financial planner's standard of care should be? And over the page you say, law degrees do not include training in medicine, architecture or financial planning. If that criticism was good as against FOS in January 2016, it was good against your process, wasn't it?
I think it is.
So one of the vaunted benefits of Dover as a licensee is that there is a legal review, yet in your own public work you have said that lawyers are not properly qualified to assess financial advice.
Correct.
So why do you bother doing it at Dover?
I think you're taking a fairly restricted view of what we say and watering it down a lot. We actually have 3 levels of review, and yes, the review team are predominantly legally qualified who then work full-time in this space reviewing statements of advice. Quite a few of them are also qualified financial planners, and of course they become quite good at what they do.
Tender that document, Commissioner.
Dover Group website article concerning Financial Ombudsman Service, is it January 2016?
Yes, Commissioner, 21st of January 2016.
21 January 2016, RCD 9999 0024 is Exhibit 2.238.
Mr McMaster, are statements of advice that you prepared reviewed by others?
Yes, they are.
You submit them to Dover for review?
Yes, I do.
Who reviews your statements of advice?
The others do.
Who are the others?
The people who work for Dover.
Employees of yours?
Correct.
Do you think that an employee of yours might be reluctant to give your advice a poor grade?
On the contrary, they enjoy doing so.
Do you keep a record of the staff member that reviews your advice?
Yes.
And do you keep a record of the staff member that reviews each advice submitted?
Each advice submitted, what do you mean?
Each advice submitted by an authorised representative that's reviewed
Yes, we
by
do.
somebody at
Yes,
Dover.
we do.
All right. The Commission sent a notice to produce to Dover seeking a log of statements of advice reviewed for various advisors. Can I take you to dov.0003.0001.001? This is a spreadsheet prepared in answer to that notice, and you can see that the particular one on the screen relates to Mr Adam Palmer, although I can say that in respect of each advisor that was named in the notice, including you, they're in a similar form. And you're probably familiar with spreadsheets that look like this.
I do believe that was pretty much created for this purpose.
This log was created for the purpose of the Commission.
Well, we have obviously have the information. We reduced it to a spreadsheet to give it to you.
So this is not a log that is maintained in the ordinary course of Dover's work. This is a log that was prepared...
We have a much more detailed and complex log maintained in the ordinary course of Dover's
Why didn't
work.
you produce that?
It would be too voluminous.
Too voluminous for who?
I think this request came in a day or two ago.
But if it exists, Mr McMaster, all you'd need to do is provide it.
It's in a computer system, and to extract the we extracted the information out in a spreadsheet form and presented it to you.
I see. But you didn't present the name of the person who'd reviewed any of the advice.
Well, we apparently didn't.
But your evidence is it that information is available at Dover?
Definitely.
It's just not been provided to the Commission.
Correct.
I see. Now, as I understand it, Dover's system of advice review means that file audits of the ordinary kind are not conducted by Dover. Is that correct?
They're infrequent. Some are done in what could be called conventional field audit.
Can I take you to what I understand to be the most recent version of Dover's combined compliance manual? It's DOV.002.001.0930. This document is entitled Dover Financial Advisors Combined Compliance Manual and Advisors Handbook, and it's got a date on it of the 1st of February 2018. Is that the most up-to-date version of this manual?
Yes, it is.
Thank you. Can I take you please to page 0967? You'll see this deals with Dover's remote audit program. And it says Dover's policy of reviewing SOAs before they are sent to clients and having MLA lawyers confirm that they are appropriate and in the client's best interest virtually eliminates the need for on-site audits. This was noted by Catalyst Compliance and follows on from ASIC's views as expressed in Report 362, Review of Financial Advice Industry Practice Phase 2 at paragraph 74, where ASIC notes advice audits are in effect file reviews. Dover's 100% SOA review policy is supported by its remote audit program. On-site audits are not necessary, and all references to audit are taken to mean Dover's 100% SOA review program and its remote audit program. Besides the SOA review policy, Dover advisors are remotely audited once every half a year and or otherwise as necessary by completing an audit program through the advisor portal. Remote auditing was introduced in 2016 as an addition to our advisor supervision system. The remote audit covers all or part of the advisor's activities and may include a list of things there, including at 3 SOAs and ROAs and related fact finds. And it says after the list, using an online system allows Dover to analyse the data in various ways. Findings are shared with advisors as a way of improving ongoing compliance. Could you explain how the remote audit program works?
It's developed by our IT team, and every 6 months the advisors have to go online and answer the questions. And the questions, you can get a feel from them what they would be from looking at the matters listed in that section there.
This is a questionnaire that is sent to...
Well, it's more than that. It's built into our management system, and every 6 months they log on and go through a series of questions, sort of some of the detail of compliance, things like maintaining their conflict of interest register and so on.
Yes, I see. Can I take you to... I tender that document, Commissioner.
Dover Financial Advisor Combined Compliance Manual and Advisor's Handbook, 1 February 2018, DOV 0002 0001 0930, Exhibit 2.239.
Thank you, Commissioner. Can I take you to another document, Mr McMaster? It's DOV.0006.0001.0006. I can't show you that document, Mr McMaster, because it's not yet found its way into the court book. I just want to ask you a few more questions about
Certainly.
the remote audit
Certainly.
program, and then I'll move to a different topic. One of the questions that is asked of authorised representatives in the remote audit program is, have you sent in all SOAs, ROAs to Dover for review before presenting to your client? Do you agree with that?
Yes.
And the advisor answers that question, and that is one of the ways that Dover attains a level of assurance that its SOA review program has worked as intended. Is that correct?
One of the ways.
Thank you. There is another question, which is question 14, that I'll read to you. It says, does all advertising and promotional material, website, blogs, newsletters, ads, publications, social media accounts, stationery, contain, and then there's a list of 5 items. The 5th is no deceptive and misleading statements or prohibited words or expressions.
Correct.
You familiar with that question?
Yes.
And the advisor is expected to self-assess whether or not any of the material used in its practice contains misleading or deceptive statements. Is that the intention of that question?
Correct.
And the 23rd question in the remote audit is, have you made all reasonable inquiries to determine all relevant personal circumstances? You familiar with that question? Isn't that the very question, or one of the very questions, that an auditor would be obliged to determine if they were doing an ordinary file audit?
Respect of the first matter, the website and so on, we actually monitor the websites automatically.
No, my question was in respect of question 23, not question 14. Question 23 was, have you made all reasonable inquiries to determine all relevant personal circumstances? Perhaps I'll ask you a preceding question and then I'll ask you the question I've already asked you again. When that question refers to reasonable inquiries to determine all relevant personal circumstances, what is it referring to?
It's a repetition of the question built in automatically to every SOA review we do, which is that you must consider the personal circumstances of the client. It doesn't displace the earlier numerous questions, it just repeats it.
My original question to you was, isn't that the very type of inquiry that an auditor would ordinarily undertake in conducting a file audit of an advisor's file?
Yes.
And in your remote self-audit system, it's left to the advisor to make a personal determination as to their own conduct.
Yes, but can I complete the sentence?
Please.
We actually have 100% real-time audit of files, and obviously that question is asked on each one of those file audits.
What does 100% real-time audit of the files mean?
That we check every statement of advice as it's created and before it goes to the client.
As an advisor is sitting in their office in suburban South Australia, you can see what they're doing and check it in real time. Is that what you're saying?
We check the fact finder for consistency with the statement of advice, and that answers your question on that.
I'm afraid it doesn't. Your evidence was that you can check in real time. How do you do that?
By comparing the fact finder and similar background documents to the content of the statement of advice.
What's that got to do with real time?
We may be talking about different things. As each statement of advice is prepared by the advisor, it's sent to Dover with all relevant background documents, and we check for consistency between those documents and the statement of advice.
Is your answer that you overreached and it's got nothing to do with real time?
I'm not sure why there's a confusion here.
I'm trying to understand in what sense you use the phrase real time.
As it happens.
As what happens?
As the statement of advice is reviewed and prepared.
By Dover?
It's prepared by the client, it's reviewed by Dover.
Prepared by the authorised representative for
Oh,
the
sorry,
client.
forgive me. The authorised representative, obviously,
And
sorry.
it's then submitted to Dover.
Yes.
And at some point in time, on your documents, usually promptly,
Yes.
it's reviewed.
Yes.
And that's what you meant when you said in real time.
Yes.
Thank you. I want to move on to a different topic and speak about appointment of authorised representatives. Dover's had very significant growth in authorised representative numbers over the last few years. Do you agree?
That's correct.
And you explained Dover's screening process of authorised representatives at paragraphs 20 to 24 of your statement. Do you have a copy of your statement there? Perhaps I'll put it on the screen. It's wit.0001.0031.0001. And if we could move to the page containing paragraph 20. I think it's 2 ahead. And perhaps if paragraphs 20, yes, thank you, that's probably fine. This is where you explain Dover's screening process, and if I can summarise it in a general sense, your evidence is that Dover has policies in place for screening of applicants to become authorised representatives of Dover. It has applicants complete a number of forms before they can become a Dover authorised representative, and it invariably seeks reference checks. Is that a fair summary of
There's
your
actually
evidence?
a lot more to it than that.
All right. What else is there?
Well, there are obviously interviews to discuss the matter generally, find out where the applicant's coming from, what their story is, the reasons why they're leaving their current AFSL.
Yes.
And there's also, we check with insurers and we check with product manufacturers to get some, particularly on the insurance side, some reliable statistical information about the advisor.
Yes.
We check third parties. We ask for statements of advice to review, and if it's available to the applicant, we ask for their most recent compliance report from their current AFSL. We then have an induction test, an induction interview with a compliance officer.
Thank you. So it's quite a elaborate process.
Yes.
Now, one of the advisors that there has been evidence in respect of in the course of the hearings over the last 2 weeks is Mr. Adam Palmer. You undertook a reference check of Adam Palmer.
We did.
And you did so in the first instance. I'll come to dealings with Genesis in a moment, but you did so in the first instance by having Mr. Palmer complete a form, which is a reference checking in the financial services industry form that was produced by Standards Australia. And that was the form I think that Dover commonly used at that point in time. And I'll take you to that document. It's dov.0005.001.0515. And I'll show you the first page of the form first so you can be sure that we're looking at the right document. So it always has that same first page. And then if we could move to 0543, please. The page I'm taking you to is Appendix D of that document, which is the reference check form. And Mr. Palmer was required to complete this form by Dover. And you can see there that there's some details that have been completed, presumably by Mr. Palmer. And he states that he joined the family business in 1996 and has been running business for 2003. Presumably he meant been running his own business since 2003. And then if we could go over the page, please. There's a request for work referees, and you can see that he's given 3 referees. And then if we move to the next page, Mr. Palmer explains that he's listed 3 professionals in the financial services industry that he has a close working relationship with and who we refer business to and receive referrals from. So there's 3 people identified who are not within his organisation. And then under current organisation, it says, if applicable, please provide the name, title and contact details of your current supervisor or compliance professional. And the name has there been redacted, but you can see the title of the person is office manager, and the email address of that person, which has also been redacted, is an email address that is of the firm that Mr. Palmer was at. So this is somebody that was at Mr. Palmer's firm when he was seeking to become an authorised representative of Dover. Did you understand Mr. Palmer to have completed the form in that way because he was, in effect, a sole practitioner?
I have no such understanding because I wasn't involved in the completion of that form at that time. It was done by the staff.
Right. Do you agree that it wasn't accurate for him to describe his own office manager as his current supervisor or compliance professional?
I think the difficulty is when you own your own business, who would be your supervisor?
Well, presumably somebody within his licensee would be his
Presumably.
compliance professional, wouldn't it?
Well, possibly, yes.
Is that what you would ordinarily understand a sole practitioner's compliance professional to be somebody within their licensee?
I've not really thought about it too much. I would say yes, and we note that we ask for a reference from the previous AFSL.
Yes, we'll come to that. Did you review this form before Mr Palmer became an authorised representative?
No.
Who did?
Our CEO and our advisor manager.
Have you discussed this form with either of them since Mr Palmer became an authorised representative?
No, I actually haven't.
All right, thank you. Over the page at 0546, there are a number of questions that Mr Palmer had to complete. And if we move straight across to 0547, you can see the 12th question there is, are you aware of any current inquiry or investigation that is ongoing and relates to issues of your character, competence or conduct? And Mr Palmer has ticked yes. And then over the page, he's given a reasonably detailed explanation of his answer to question 12. And he says, at the most recent AMP audit, AMP are currently reviewing files and coming back to me with outcome. The issues identified were around the statement of advice not being up to the standard that they require. They also required me to complete updated courses with regards to SMSF, direct equities and margin lending. As discussed with Peter and Terry, we joined Genesis around May 2013 and there was no induction or training provided when we joined. By November, I requested that somebody come and check if we were doing the advice the way they wanted. It was around March 14 that an advice manager started working with us. Shortly after this, our files were audited. So Dover was aware of these you were aware of these circumstances before Mr Palmer submitted this form. That's correct?
I'm not sure I was aware of it before he submitted the form. I did certainly become aware of issues after he submitted the form.
You'd had a discussion with Mr Palmer before he completed this form?
I don't recall.
Does it help you to recall when you see the line there, Peter and Terry, as discussed with Peter and Terry?
Yes, but I can't recall.
Would it surprise you if you'd spoken with Mr Palmer before he completed this form?
Normally I'm not involved at that stage.
At the recruitment stage, if I can call it that?
At that point, yes.
All right. Who would have reviewed this form within Dover at that
It would
time?
have been Peter and Flo.
Who's Peter?
Peter Thompson.
And sitting there now, would the admissions that Mr Palmer's made, quite frankly, in that
On
form
a number of things.
have caused you concern? Had they been brought to your attention at that time?
They were
They were brought to your attention
Yes.
at that time. When were they brought to your attention?
soon after.
I see. And did they cause you concern?
Yes, they did.
All right. At the time Mr Palmer completed this form, which was the 14th of October 2014, he'd already been told that he could become a Dover authorised representative, hadn't he?
I'm not sure.
Can I take you to another... Oh, I might tender that document first, Commissioner.
Reference checking financial industry form re Palmer DOV 0005 0001 and 0515 exhibit 2.240.
Can I take you, please... We'll come back to this document, but can I take you to DOV.0004.001.0055? You can see this is an email chain from Mr Palmer's email account, and at the foot of the page he informs his then licensee Genesis. In the fourth line, we are moving to Dover Financial Advisors, and that's on the 25th of September 2014. And then if you look at the top of the page, you can see that he has forwarded that email to Mr Palmer on the same day, 1 minute after sending it to Genesis, and said FYI. Would Mr Palmer told at the meeting with you and Mr Thompson that he could become an authorised representative
Mr. Palmer was originally told he couldn't become an authorised representative
When was he told that?
sometime before then
By?
by Peter Thompson, if you like, on my instruction,
And why was he told that?
because he disclosed to us the circumstances of AMP and we were concerned by it.
So why then on the 25th of September do you think he felt sufficiently comfortable not only to tell Genesis that he was moving to Dover, but to forward the email to Mr. Thompson?
Because we had a series of discussions after that, and I can recall I wasn't involved in them, but Peter was coming back to me and reporting, and the details of the AMP Genesis situation unfolded, and when it was properly explained to us, we were happy to take him on.
Did Mr. Thompson meet with Mr. Palmer in the first instance?
Yes.
And then you and Mr. Thompson together met with Mr. Palmer?
I actually can't recall meeting with him,
Yes.
but Peter was keeping me posted on the conversation, because I originally said no, and it was then umming and ahhing, and then we eventually said yes when we had all the information.
Pardon me. What information were you acting on when you said no?
The base principle that there'd been a problem with the AMP group.
And did you know what the problem was?
Well, we're very sensitive to property for a number of reasons. We have an absolute rule against off-the-plan apartments, and we have an absolute rule against the advisor being paid by anyone other than the client in a property advice situation. And we have a nil tolerance of breaches of either of those two. So we, at first, were concerned that this was an apartment sale type situation, and we said no. When the full information came to light, we discovered it was genuine buyers advocacy, where Mr. Palmer, through a related entity, was providing help to his clients to buy homes, to help them with upgrades, downsizes, homes for children, that sort of thing. Now, we actually encourage that sort of advice on the basis that to omit the most valuable asset from a financial plan is probably negligent. So we found that there was a commonality there, and our early concerns that it was involved in something improper, what we feel is improper, fell away. We're also very alert to subtexts. If I could put it delicately, if a client invests in direct properties such as their home or an investment property, they don't have any money to invest in funds under management. So the institutional AFSLs don't like direct property. They discourage it, if not ban it, as an investment possibility. So knowing that and feeling and writing that financial planners should be moving to a fee-for-service model, where the most valuable asset that people own, their home, and obviously rental properties, investment properties and similar, can be the object of advice and should be the object of advice on a fee-for-service basis, we then proceeded.
Well, can I ask you something arising from that? What did direct property have to do with this?
The issue why he was leaving AMP was to do with recommending direct property to his clients.
Well, that's not what he said to you in this form.
It's what he was telling us in the meetings.
It's not what he says in this form he said to you at the meeting before he completed this form.
It was what he was telling us in the meetings.
You now have a recollection of meeting with him.
Peter was telling me of the issue, and I was deliberately staying a distance away from it.
Did Mr. Palmer discuss this with you?
I don't recall discussing it with him at all.
So what do you recall?
I recall being told of the problem at AMP, initially saying no, then over a period, further discussions were held between Peter and Adam, when, if you like, the correct picture of what had happened emerged. And when we knew what the correct picture was, we agreed to take him on, subject to the conditions, obviously, that the direct property activity be in his financial services guide, be disclosed in statements of advice when he's recommending that, be on his conflict of interest register, and he follow our additional rules that there be no off the plan because of the Commission's problem, and that he not be paid by anyone other than the client.
Did Mr. Thompson tell you that he was concerned that Mr. Palmer had completed a reference checking form and made what appeared at first glance at least to be reasonably frank disclosure about the problems he had at AMP, but hadn't mentioned anything about direct property that you appear to have been so concerned about?
It had been told to us. It had been told to us.
My question was, did Mr Thompson express any concern to you that in the written document he submitted to you, he didn't say that?
No.
He presents the problem at AMP rather differently. He doesn't mention anything about direct property, and he says, as discussed with Peter and Terry. The problems he identifies in the written document that he submitted to you were a current ongoing audit, statements of advice not being up to the standard they require, and the requirement for further training in SMSF, direct equities and margin lending.
Fine, that's what he wrote there.
Wouldn't Mr Thompson have been concerned that the explanation being given in this document is different to the explanation that he had given, that Mr Palmer had given to him previously? And that you were so concerned about that you had said Mr Palmer could not become an authorised representative of Dover?
The discussions regarding property occurred. The fact that the application doesn't marry up with those discussions perfectly is, by the looks of it, just a historical fact.
Can I take you please to Exhibit 17 of your statement? It's DOV.0005.
Will we do that? Are those emails to be tendered, Mr Costello, or are they already part of the record?
No, they're not. I should tender them. Thank you, Commissioner.
Emails between Palmer and Thompson and others, 25 September 14, DOV 0004 0001 0055, Exhibit 2.241.
Now, you've said that Dover seeks reference checks from
Yes.
prior licensees, is that correct?
Correct.
And you did in respect of Mr Palmer.
We did.
And do you recall when you did that?
From memory, it was in October.
Is it the ordinary practice of Dover to do reference checks before taking on a new authorised representative?
It's quite the contemporaneousness of the matter. These things tend to happen in a chicken and egg situation, where you might agree in principle, then do a reference check. It doesn't all happen perfectly according to the textbook.
What's the ordinary practice?
You would ordinarily do it before the person was appointed, but not necessarily before you said, yes, subject to due diligence, it's okay, you can come on board.
All right. Do you know if that's what you did in the case of Mr Palmer?
I don't. I've looked at the file since then and seen the reference check going to Genesis on a date in October.
In October?
I think it was October, yes, from memory.
Well, I'll come back to that in a moment. Would Dover's practice have been not to have made Mr Palmer an authorised representative until it had obtained the reference check?
Yes, ordinarily that you would expect that to be the case.
You would ordinarily expect that until you had heard from the prior licensee, you wouldn't authorise somebody.
There will be exceptions because responses from prior licensees often aren't forthcoming. And you have a problem with continuity of cover, if you like, and responsibility for the clients. So it is quite possible that you could take on someone, for example, subject to reference checks and other due diligence turning out okay, which it normally does.
Would you be surprised if it was the case that Dover didn't seek a reference check of Mr Palmer until Boxing Day?
Yes, I would be.
And if the reference check came back and AMP had expressed the same types of concerns that Mr Palmer had alluded to in the document that he'd completed, would that have been sufficient reason for you of not to have not authorised or deauthorised Mr Palmer?
No, it would not have been.
Why?
Because if you like, for want of a better word, a poor reference check is actually quite normal in this situation. We rarely see, if you like, a positive reference check coming from an institutional AFSL. There's either no response or a poor response. That's normal.
Is that a function of the type of applicants, the type of applications being received by Dover?
I don't believe so.
What is it a function of?
I think it's a function of mammon. When a person leaves an institutional AFSL, it's a stressful situation, it's even a distressful situation. The advisor will be very concerned about their income, the capital value of their practice. The old institutional AFSL will be equally concerned about their funds under management and premiums under advice, and they'll be interested in doing things to preserve those values. And it is in that environment, that conflict situation, you see all sorts of things happen, and a poor reference check is the least of them.
Can I show you another part of the bundle I've already taken you to that commences with DOV.0005.001.0515?
Certainly.
And if we could go to the 0568, which is the last page of the bundle. See, this is an email from an address that's described as fees admin, but it's somebody in the Dover team, to mail@genesiswealth.com.au. Do you understand Genesis Wealth to have been Mr Palmer's prior licensee?
Yes, I do.
You see the date is the 26th of December at 7:10 p.m.
Yes, I do.
Do you know this staff member at Dover?
When? Yes.
Is this somebody in the Cheltenham office or is this somebody in the Vietnam office?
Vietnam office, and I believe, I could check the file, I guess, but I believe they're sending a copy of the letter which went previously.
There's no indication that that's what they're doing on the face of this document.
There is actually a letter on the file in the court book, I believe from memory, with an earlier date, in letter form.
Well, this letter says, "Dear Sir, Madam, please find attached a compliance check for Adam Palmer, who was previously licensed through your organisation. Please reply to Florence T. or Peter Thompson. Thanks for your assistance in this matter."
I believe there was an earlier letter.
Right. And then if we go back one page to 0567, see at the foot of the page there, 3rd of February now, another email to Genesis. "Hi team, just a kind reminder relating to our email below. Could you please get back to us?" Could that be...
Could we go back a page, please?
Yes.
There's a name there on one of those forms. The name of the person is she's actually the National Advisor Manager at AMP.
Yes, we'll come to that. I just want to get the sequence right. If we go to the last page in that bundle, 0568, there's the Boxing Day email from Dover's Vietnam office. If we then move to 0567, the foot of the page, there is an email of the 3rd of February from the same Dover staff member chasing up Genesis.
Yes.
And then above that, there is an email from Genesis that copies in the fees admin address of Dover, where somebody within Genesis called Alana is forwarding the email on to Claudia in the hope that Claudia might be the right person.
Yes.
And then if we move to the next page, 1st of April now, there's an email from Dover again to Genesis. Hi Claudia, just a kind reminder with regards to the below email, could you please get back to us or pass on to the responsible one? Adam advised us his main contact in Genesis was Grant Scott. I also attached a consent form for your reference. So far as I can ascertain, a reference was first sought from Genesis on Boxing Day 2014. There was then a very considerable delay on the part of Genesis in coming back to Dover, and that you say is consistent with other experience you've had with large licensees. And do you recall if you ever got a reference check from Dover? From Genesis.
I believe we did not get one.
Did not get one. Why, in circumstances where Mr. Palmer had confessed to at least some of his problems in writing and other of his problems orally to Mr. Thompson, was it important for Dover to seek a reference check?
Because it's form. And
Because
we're
it's
expected and required to do that.
Did you say you're expected
Yes.
by?
Well, ultimately ASIC, in terms of observing, in the spirit of Section 9112 capital A.
There's an expectation that you will
Yes.
seek to properly reference check incoming applicants.
I think so, yes.
Is there anything that AMP could have said to you that would have caused you not to have appointed Mr. Palmer?
Yes.
What?
Fraud. A detailed list of significant errors, particularly if when we looked at those errors, it would be likely that they would reoccur in the future.
What about if they told you that he had received the lowest possible audit rating in his last audit? Would that have concerned you?
Not necessarily,
Why?
because we've learnt that what happens in a situation of an unsupervised advisor who's subject to volume quota KPIs doesn't happen in our environment where we have close supervision and support for the advisor. And indeed, that's the situation that's unfolded here. It's also unfolded in many other similar situations
When you say it's unfolded here,
with Mr. Palmer.
you haven't had any difficulties with Mr. Palmer's advice?
We have not had any difficulties with Mr. Palmer's advice.
Thank you. Do you accept, though, that Dover didn't seek a reference check of Mr. Palmer until 2 months after he'd become an authorised representative? And
No,
3 months
actually,
after you
I
told him he could become one?
I'm relying on my memory. I believe the letter was dated in October.
All right. Can I take you to a different document about a different advisor now?
Certainly.
Another of Dover's authorised representatives is Julie Hamilton.
Correct.
And you say in your statement at paragraph 44 that she was appointed an authorised representative of Dover on the 17th of November 2014.
Correct.
And it appears from the documents in your statement that Ms Hamilton was formally appointed on or about the 27th of November, but with an effective date of the 17th of November. Is that a common practice?
Sorry, say that again, please.
She was formally appointed on or about the 27th of November, formally authorised, but with an effective date of the 17th of November.
Yeah, it is. You've got 10 days to put people up on the register.
Right.
And normally, as a practical matter, you're trying to avoid an overlap, so you have a continuity of responsibility.
I see. Can I take you to Exhibit 35 of your statement? It's DOV.0005.001.1055. Can I take you first, please, to 1062 And if that could be made bigger, the bottom half of the page. This is an email from Ishta Rampul at Dover to Ms Hamilton on the 17th of November. It says, I'm currently working with Peter and Florence on your application with Dover. I've received your documents today and have already sent it to the relevant department. However, the RCTI form was not filled. What's an RCTI form?
It's basically, I think, a recipient initiated tax invoice.
Thank you. Then if we can go back one page to 1061. There is some further correspondence about the RCTI form, and in the last line of the email at the foot of the page, there's a question, please also do let me know when you wish to be appointed by us. And up the page, Ms Hamilton says, my resignation finalised today, so I'm good to start straight away, which is responded to with, okay, I shall work on it as soon as I get your signed and filled RCTI. See that?
Yes.
Then if we go over the page again to 1059, there's an email from Ms Hamilton. This is 18 November 2014. She says, good morning, Terry. When you have time, can I come to the office to see you, please? Did you know Ms Hamilton before this?
I don't have perfect recollection of it. She came on board with a group, actually.
All right. Then if we go over the page to 1058, you responded, I'm out of the office today, but Amy will contact you to make an appointment. Can you fill me in? Has a problem popped up?
Yes.
See that? And that generates a long response from Ms Hamilton, which starts at 1057. Can we blow up the email at the bottom of 1057? You can see there, Ms Hamilton writes, hi Terry, on Monday my world imploded. I wanted to come and speak with you face to face, but here goes. I had a teleconference with Head of Compliance and the State Manager for FinWiz, that's Financial Wisdom. CBA Financial Planning has been under immense scrutiny over the past few months, and as you know, Financial Wisdom is owned by the CBA. In my last audit, there were issues noted in that particular audit that I had in my process all through my files in the time with Financial Wisdom. I asked myself at the time, why are they doing this? And on she goes. Then says further down, a few weeks ago, compliance wanted to look at some more files, so I sent them through. Then I got a month's suspension while this was happening. I really didn't think it would come to anything. I wanted to resign a month ago, but our BDM said I should wait. And oh, Julie, we will assist you with your transition to Dover and I'll support you. It only takes about 6 weeks. Everything seemed to be falling into place until Monday, and I was told that Financial Wisdom had or will report me to ASIC with a significant breach. I was stunned and upset, and eventually I asked how long it would take before my files to be released before I can move to a new licensee. And then she says further down, I'm not sure where this leaves me, Terry, or even if I can get a licence again. I sent a witness letter to her former employer telling her that I would honour any cost up to $20,000. I'll come back to that last part of the email later. This email was on the 19th of November. If we can then move to 1056, we see your response. You say there, hi Julie, I'm not unduly troubled by this. Why were you not unduly troubled by the fact that Ms Hamilton's licensee had told her they were going to report it to ASIC for serious compliance concerns?
Because the two events that were notified to me are events that would be automatically picked up in our review processes, and I see them as being more supervision problems which reflect poorly on the institution than I do on the individual.
Well, that's similar to what you say in the next line. Could not have happened at Dover because we read every SOA twice and we would have picked up any compliance concerns early in the piece. And then you say that it reflects poorly on Financial Wisdom and its compliance team. And then you say, in the third paragraph, Dover will take you on. We are happy to do so with immediate effect, i.e. today or tomorrow if that helps,
Yes.
and allows you to achieve a continuum of service with your clients.
Correct.
You hadn't sort of reference checked for Miss Hamilton at this point?
We'd been in discussions with the group she was in for quite a while, and we were very aware that they were in dispute with Financial Wisdom, and these, as they announced progressively their departure from Financial Wisdom, these issues became live. They popped up.
You were so unconcerned by a licensee of the size of Financial Wisdom reporting Miss Hamilton for a serious compliance concern that without further investigation, upon being told of that for the first time, you immediately agreed to take her on as an authorised representative.
The particular issues in concern were expensive premiums and also a loss of continuity of insurance benefits on transfer to of clients' monies to Colonial First State. Now, under our review processes, it's extremely unlikely that those two events could occur. So what was described to me as being the problem, I saw more as a supervisory problem reflecting on the institution than on the individual.
You were content to take Miss Hamilton at her word.
Yes, I was.
Why?
Because in the past I've done so, and events have normally proven that that's a good way to go.
Well, perhaps I'm mistaken, Mr. McMaster, but I thought your evidence earlier was that you ordinarily wouldn't authorise somebody until you had completed a reference check.
Ordinarily, but
in this case where you'd been told that an authorised representative was to be reported to ASIC with serious compliance concerns, you were quite content to forego the entirety of Dover's processes and immediately appoint this lady the very day she told you that.
With respect, she was member of a group, and I think others had come on board already. It was a small group of 3 or 4.
There's no obligation to take them all, is there?
We were very aware of the circumstances.
What circumstances?
A commercial dispute.
Well, a commercial dispute doesn't generate a report to ASIC for a serious compliance concern, does it?
Very often it does.
That's your experience?
Yes.
I want to put it to you, Mr. McMaster, that you are trivialising reporting of serious compliance concerns to ASIC.
I would reject that proposition.
You have just said that oftentimes serious compliance concerns are reported to ASIC for commercial reasons.
I have seen that happen before, yes.
And you were content to presume that was what was happening here?
It had all the hallmarks of that transaction.
What were the hallmarks?
A prior dispute between the parties. Then towards the end, sudden compliance concerns, which really hadn't been there earlier.
So you were content to assume that Ms Hamilton was an authorised representative that was capable of giving financial advice in a compliant way and was being unfairly targeted by her then licensee?
Yes, particularly under our supervise and support program, where we literally check every statement of advice 2, then 3 times. So the errant behaviour, or perhaps only incident that occurred, is very unlikely to occur again.
You say in your witness statement at paragraph 45 that none of Julie's clients have complained about inappropriate advice or any other matter.
Correct.
I want to show you an extract of another document. It's RCD.0006.002.0290. This is an extract from ASIC's Register of Financial Advisors. You can see at the top of the page it relates to Ms Hamilton.
Yes.
And it says in the top right-hand corner, ceased. And if we move down the page, you can see a red box. Disciplinary actions, 29 November 2017, AFS banned/disqualification, and that banning order lasts until the 28th of November 2020. Were you aware of that?
I'm very aware of it.
You didn't think that that was relevant information to present to the Commission?
I think the sentence was there's no complaint. This is a difficult territory. I actually represented Julie in the hearing at ASIC, and I'm actually still to this day quite comfortable her advice was in her client's best interest and prioritised their interest over hers.
Well, Mr McMaster, I want to stop you there. My question to you was, you didn't think it was relevant to present this information to the Commission?
I agree that that does not look good, and I think on reflection it is. There was
Did you deliberately decide
no,
not
there
to
was
present this information to the Commission?
no intention to deliberately exclude it.
Put it to you, Mr McMaster, that it was misleading for a man of your qualifications to use the present tense in your statement when speaking of Ms Hamilton's clients in circumstances where she is now banned.
I agree there should have been more clarity around those words.
It was misleading, wasn't it, to say that you have not had any complaints about inappropriate advice or any other matter from any of Julie's clients?
No, I don't believe it is. That is
Julie
correct.
doesn't have clients anymore, does she?
Oh. I take your point. Clearly it was meant at the time.
At what time?
At the time that she was banned. I take your point.
It wasn't meant at the time you signed your statement,
I wish I could explain.
or at the time you made your affirmation when you got into the witness box today.
With respect, there's no intention to mislead. The statement that there were no complaints about Julie is correct, and if there's a wording error there which implies the present tense rather than the past tense, it was not meant to mislead.
Well, it's not just a wording error, is it? Because it's a complete omission of the fact that Ms Hamilton suffered the most serious consequence that can become an authorised representative and was banned by the regulator.
That's correct.
In your statement, you give evidence about another... Oh, I tender that document, Commissioner.
ASIC Register of Financial Advisors record concerning Hamilton, RCD 000600020290 becomes Exhibit 2.242.
With respect, is it possible I could explain what happened?
If you wish to make some statement, go ahead.
I represented Julie in the ASIC hearing, and it was very sad. After Julie left CBA, CBA representative visited her clients and told the clients that there may be compliance issues with the advice they'd been given, and that they would pay a small amount, say $1,000 or so, provided the client signed a complete indemnity and release and transferred to another financial wisdom advisor. Julie only had a very small practice. It was best described as a micro practice out in Gippsland. More than half of the advisors accepted the money and transferred to another advisor.
You said more than half the advisors. I think
half the clients, my apologies.
I think you meant half the clients.
Sometime afterwards, Colonial First State wrote to Julie and said they were going to deny her access to their platform and also stop the payments that her clients had authorised would be made to her. And she contacted us and told us what had happened, and we said to her, look, we don't think you have any choice but to change platforms, because you can't satisfy your duty of care to your clients. You can't continue to act in your client's best interests. And she did. She transferred all of the clients to Macquarie's platform. I understand from the ASIC hearing that Colonial First State complained and said they believed that was prioritising Julie's interests over her own interests. And in summary, that was the main argument accepted by ASIC when they banned her. So obviously I believe that the transfer was in her client's best interests and prioritised their interest over hers, but obviously ASIC disagreed. But it's, I think you need perspective onto what the banning order actually was based on.
Do you agree that a banning order is a very serious matter?
I do.
And do you agree that they are not taken lightly by ASIC?
I do.
There's an elaborate process before a banning order is made, isn't there?
Yes, there is.
And matters are thoroughly investigated?
I believe so.
Didn't you say that you acted for Ms Hamilton in the
Yes.
process?
Yes.
Well, do you know so?
Well, I know so.
And there is significant opportunity for the person subject of the possibility of a banning order to put their case forward, isn't there?
There is an opportunity.
And was that done here?
I did it for her.
And it was not accepted.
It was not accepted.
And I'm going to put it to you again. Just as you were content to proceed to authorise Ms Hamilton in circumstances where you knew she was being reported to ASIC for serious compliance concerns, you are trivialising the seriousness of this banning order by the statement that you have just made.
I reject that. I'm noting what actually happened in the process.
You just have a different view to the regulator.
Yes.
And is that because you're a soft touch?
I don't believe so.
All right. Another one of the advisors that you give evidence about in your witness statement at Dover is Koresh Horton.
Mm.
At the time that you authorised Mr Horton, his previous licensee told you that they had concerns with his advice. Is that correct?
He was in the same group as Julie Hamilton.
Thank you. And those concerns didn't stop you from authorising Mr Horton as...
No, because in the meeting process we'd been fully apprised of the commercial conflict that was happening.
Yes. And again, you say that none of Mr Horton's clients have complained about inappropriate advice.
Correct.
Is there anything else that you'd like to tell the Commission about Mr Horton?
Obviously he was banned too, but I do...
Well, just wait there,
I
Mr
take your
McMaster.
point. It should be in there.
How long was Mr Horton banned for?
3 years, I believe.
Can I take you to another document, RCD 0006 0002 0291? Could that be made a little larger, please? See, it relates to Koresh Daniel Horton. The status in the top right-hand corner is ceased. And in the red box it says 28 September 2017, permanent.
Correct.
Mr Horton was permanently
Oh,
banned,
my
wasn't
apologies. I thought it was 3 years. Forgive me.
he? Is a permanent ban the most serious action ASIC can take against an authorised representative in your
Yes, it
opinion?
is.
And what's your view of the banning order made against Mr Horton?
I made the contravention report. If I could explain what happened, I think it's
No,
necessary.
I'd like you to attend to my question.
I think
What is your view of the banning order made against Mr Horton?
I think it's excessive in the circumstances, sir.
Does the fact that two of the advisors that you were content to authorise on the assumption that it was a commercial dispute with Financial Wisdom were banned by ASIC, one for 3 years and one permanently, give you cause for reflection about the way you recruit financial advisors?
It does.
Do you concede that you got it wrong in both of these cases?
Mr. Koresh was, the events which gave rise to the banning were quite separate and different from anything which happened at Financial Wisdom.
But you knew that they had concerns about him.
Yes.
You knew that before you authorised him.
Yes. And
You were
they
content to authorise him notwithstanding those concerns without properly investigating them.
No, we did. We were aware of it.
You were aware of the fact of concerns,
Yes, we were.
but you dismissed them.
No, we looked at other evidence and other experiences we've had. Can I explain what happened?
No, Mr McMaster, because all I'm interested in understanding at this point in the examination is whether you are prepared to accept that in the case of two authorised representatives who have had banning orders made against them, you got it wrong.
I think I got it wrong.
Thank you.
Is this document to be tendered, Mr.
Thank you,
Costello?
Commissioner.
ASIC Register of Financial Advisors record concerning Horton RCD 0006 0002 0291 Exhibit 2.243.
Mr. McMaster, I'd like to take you back to the email exchange that you and Ms. Hamilton had that I took you to earlier. It's DOV 005 001 1055. Could we please move to 1058? You recall that I read rather too longly this exchange out earlier.
Yes.
And I paused before I got to the end. You can see about the fifth last line, a sentence commences, I sent a witness letter to, and there's a redacted name there, it's the name of her former employer.
Yes.
Telling the former employer that I would honour any cost up to $20,000 per claim if there was any litigation connected with any of my clients while he had them on his register.
Correct.
And then if we could move back one page to 1057. In fact, could we go one further back to 1056 perhaps? This is your response. And again, I took you to this earlier, but I'll take you to a different part now. The bottom of the page, the last three paragraphs, perhaps they could be popped out. You say, this is you to Miss Hamilton, don't offer to indemnify anyone. You should formally withdraw any offer you have made and state the offer was made under duress. In what capacity are you acting when you send this email?
A mixed one, really, because I was quite concerned that she'd given a carte blanche indemnity and that the other party would just automatically hand out lots of $20,000 on the strength of it.
Are you giving advice to her here in your capacity as a lawyer or in your capacity as the responsible manager of Dover?
Sometimes it's hard to know which cap you're wearing.
I imagine it must be. The next paragraph reads, the whole question of loadings or exclusions is complicated and quite a few people are involved in each client transaction and you are a long way off having to pay any money. First, a client has to complain. Then if one does, they have to make out quite a few evidentiary points, including validating damages, proving causation, and showing that your actions were not actions of a reasonable financial planner. It's a big task and hard to do. Certainly you should not just conclude the worst just because some compliance guy says there is a compliance problem. As you rightly observe, if there was a compliance problem, why did financial wisdom not say so before? On what basis did you advise Ms Hamilton that she should state the offer was made under duress?
The fact that it was an offer made under duress in a state of distress, not understanding all the implications of what she was doing, and virtually in a state of panic.
Dover was previously a member of the Financial Ombudsman Service.
Yes.
More recently, it's left that scheme and become a member of the Credit Investment Ombudsman.
Correct.
Why did Dover move from the Financial Ombudsman Service to the Credit Investment Ombudsman?
Because in a particular matter, I was very upset that a case of elder abuse and a case of criminality wasn't reported to the appropriate authorities.
I want to show you some correspondence from the Financial Ombudsman Service to ASIC. It's FOS.006.001.2866. You can see this is a letter of the 8th of December 2016 and it's from the Financial Ombudsman Service to ASIC. And under the heading their dispute, it says this information has been provided following the resolution of a dispute. FOS is concerned about the conduct of Dover during that dispute. A short summary of the dispute follows. The applicant complained to FOS about the advice provided by an authorised representative of Dover. The applicant claimed that the advice provided was not appropriate nor in her best interests and was incorrect regarding capital gains tax. During the course of the dispute, Dover, in a letter addressed to the applicant dated 10 August 2015, outlined that making false complaints about financial advisors can give rise to defamation, actions and similar proceedings. Allegedly issued correspondence on 10 August 2015 in relation to the applicant's dispute to her mailing address addressed to the occupant. Issued correspondence to a party not privy to the dispute, a third party, on 14 August 2015 identifying details of the dispute. Provided FOS with a letter addressed to Centrelink identifying the applicant and the third party making allegations of fraud. It is unclear if this letter was subsequently sent by Dover to Centrelink. Are you aware of this matter, Mr McMaster?
Yes, I am.
Why was the letter of the 10th of August that threatened that making false complaints about financial advisors can give rise to defamation actions and similar proceedings sent?
I don't recall the actual letter itself. I remember saying that statement because I was mistaken.
Did you draft the letter?
I would have.
Did you sign it?
I would have.
Is it your common practice to make threats of that kind?
No, it's not.
If we could move to 2867 in the document.
Just interrupting you there. So this was an unusual threat to make, was it?
Yes.
You can't recall what it was that brought about the making of that threat?
Yes, I can.
I thought you told counsel that you
No,
could not.
no, my apologies. I know the facts of the case, obviously.
Go on, Mr Costello.
Under the heading Possible Systemic Issue, it says, as Dover is the holder of an AFSL, it has an obligation to provide financial services efficiently, honestly and fairly. It is our view that for a financial services provider to meet this obligation, it needs also to comply with relevant laws associated to the provision of financial services, including the Privacy Act 1988. Does Dover agree with that view of the law?
I think you'll find in the matter there was no breach of the Privacy Act.
No, my question was, does Dover agree that that is an accurate statement of the law?
Yes.
The letter goes on to state that the conduct of Dover in the dispute by releasing information to a third party is arguably a breach of privacy. FOS Systemic Issues has approached Dover in relation to the conduct. Dover has responded to FOS outlining that it does not agree with our view.
Correct.
Was the view you were not agreeing with the view of the law? Or the view that there had been a breach, or both?
The issue was reporting Centrelink fraud to Centrelink.
My question was, did Dover dispute FOS's view of the law? Did it dispute there had been a breach, or did it dispute both?
It disputed there'd been a breach.
Thank you. Then under the heading Serious Misconduct, the letter states, Clause 11.3 of the FOS Terms of Reference requires FOS to report all serious misconduct to ASIC. Serious misconduct is defined as conduct which may be fraudulent, grossly negligent or involve willful breaches of applicable laws or obligations under the Terms of Reference. Then specifically notes paragraph 13.3 outlines that a financial services provider shall not instigate defamation action of any kind against an applicant in respect of allegations made to FOS by the applicant about the financial services provider. It then says in the next paragraph that it's critical for the effective working of an EDR scheme that the applicant is not made to feel threatened or coerced into withdrawing complaints lodged against financial services providers. Do you agree with that?
I do.
Is this conduct consistent with a culture within Dover that client complaints are to be fought?
It's actually a very exceptional case, a complete one-off with very unusual circumstances.
It would have to be an exceptional case to have warranted you to threaten defamation proceedings against somebody, notwithstanding the Terms of Reference of FOS of which you're a member expressly prohibited it, wouldn't it?
And I agree, and that was an error on my part.
Yes. Is this why Dover left FOS?
Yes, it is.
Because of this dispute?
Well, general lack of confidence in the process that was engaged in that matter.
Did Dover take any steps to apologise for this conduct?
No.
Why?
The matter was a conflict. The matter went through FOS, the determination came out and the amount was paid, compensation to the claimant.
Do you accept that somebody reading this letter and reading your email to Miss Hamilton might reasonably form the view that you believe client complaints are to be fought and fought in any way possible?
I think that would be completely unreasonable, actually.
I tender that document, Commissioner.
Letter FOS to ASIC, re Dover 8/12/2016, FOS 0006 001 2866, Exhibit 2.244.
Oh, Pauline. Thank you. Could I please call up RCD.9999.0025.0001? Mr. McMaster, this is an extract of the Corporations Act. And if we move to the next page, please. You'll see here that this extract is particularly of Division 6 of Chapter 7 that commences at 917A. You're familiar with this provision?
917A, yes I am.
Thank you. Can we move to the next page, please? And could we please blow up 917B and the text beneath it? Are you familiar with this provision, Mr. McMaster?
I've not had reason to look at it specifically, but I've read it before.
You've not had reason to look at 917B specifically?
Not specifically that I'm aware of, yeah.
All right. Reading it now, does it seem familiar?
Yes.
This is a very important provision for licensees. Do you accept that?
That's correct.
This is a provision that foists licensees with liability for the acts of their authorised representatives.
In certain circumstances, subject to other rules.
Yes, that's right. But this is the provision, this is the default rule that applies. Do you accept that?
I wouldn't call it the default rule.
What would you call it?
Well, I think Section 917B is one of a series of sections which interlink.
Quite.
And to understand the legislative intention, you have to look at the series of interlinks.
All right. Do you accept that 917B, operating of its own force, imposes liability upon licensees for the acts of authorised representatives?
Yes.
And that there are other circumstances in which that liability will not attach?
Yes.
Notwithstanding 917B.
Okay, yeah.
You accept that? Thank you. Can I take you to another document? Oh, in fairness, Mr. McMaster, I'll take you to another provision which is perhaps one of the exceptions you had in mind. Could we move to the next page, please? You'll see there 917D, exception if lack of authority is disclosed to client. And that's one of the exceptions perhaps that you had in mind.
Yes, definitely.
That operates in some circumstances to reduce the scope of the liability imposed by 917B.
Correct, yes.
And are you aware of any other provisions that limit the scope of 917B?
No, I'm not actually.
Thank you. Can I take you to another document? It's ASIC.0022.0001.1127. This is Dover's client protection policy, which has existed in, or did exist in various forms at various times.
Correct.
But I think I'm right to say, and you'll correct me if I'm not, the provisions I take you to were in identical or very similar form at all relevant times that this policy was
I
in.
expect that will be the case.
Thank you. Could we please blow up the first paragraph, Roman numeral I? This is the paragraph that sets out the intention of the document. Dover's client protection policy sets out a number of important client protections designed to ensure every Dover client gets the best possible advice and the maximum protection available under the law. You should read each section of Dover's client protection policy carefully and make sure you understand it and agree with it before you decide to accept our advice and instruct us to implement the advice. This was a document that formed part of the contract between every Dover authorised representative and their client.
That's correct.
Thank you. Can I then take you further down the page, and could 1.3 be blown up, please? See 1.3 reads, under the Corporations Act, Dover is not responsible for anything done by your advisor which is not within the authority provided by Dover in these circumstances?
Correct.
Is that accurate?
I haven't got the whole document there, but I believe in the context of the other paragraphs it is.
You maintain that that's an accurate paragraph?
Yes, when you read the whole series of paragraphs.
Thank you. Could 1.4 be blown up, please? Your advisor is only authorised to provide advice that complies with the Corporations Act and related regulations and regulatory guidelines. Your advisor cannot provide advice or do anything else which breaches a law or an ASIC regulation. Is that statement accurate?
Correct. Yes, it is.
You maintain that's an accurate statement of the law?
Yes, it is.
Thank you. Could we move to the next page, please, 1.5? You'll see here there is a carve-out at the top of the page. Your advisor's authority does not include. And you'll see, for example, paragraph E, failing to adequately research a recommended financial product. F, failing to consider your circumstances when recommending a financial or service. Presumably that's meant to say financial product or service.
Correct.
Failing to provide personal advice in the form required under the Corporations Act. J, recommending a financial service that a reasonable financial planner would not recommend.
Correct.
L, failing to advise you of a negative consequence of a recommended action.
Correct.
M, any act that breaches a law of Australia or a state of Australia, including the law of negligence, the criminal law and the corporations law, or any ASIC regulation or regulatory guideline. See
Correct.
that? The entire intention of this document is to minimise Dover's liability for the work of its authorised representatives. That's correct, isn't it?
As a sentence, that is correct.
Can I return to the first page, please? When it says in Roman 1, Dover's client protection policy sets out a number of important client protections designed to ensure every Dover client gets the best possible advice and the maximum protection available to the law. That is a lie, isn't it?
No, it's not, because that clause, if you like, comes out of the Corporations Act, and the advisors are still liable, and we actually discussed this with the advisors, so that if they act outside the authority, they understand that they're responsible for that action.
Mr McMaster, the effect of the provisions I have just taken you to is that a Dover authorised representative has authority to provide compliant advice only.
Correct.
And it completely sets at naught the statutory protection erected by 917B, the purpose of which is to foist liability upon the licensee.
No, I believe you've got to read section 917D as well.
and you think that you can properly read section 917D to exclude all liability a licensee may have?
The origin of this rule came from a FOS determination where that was actually said to us, that they couldn't see evidence that we had warned the client that we weren't liable for fraud, therefore 917D didn't apply, and therefore we were liable under section 917B.
What, as you understand it, could Dover possibly be liable for if this document was given legal effect?
Inappropriate advice not in the client's best interest.
No, Mr McMaster. I've just taken you specifically to paragraphs in paragraph 1.5 where you state that the advisor's authority does not include failing to research a recommended financial product, failing to consider circumstances when recommending a financial product or service, failing to provide personal advice in the form required under the Corporations Act, any act or breach of any Australian law of a state, territory or the Commonwealth, including negligence in the criminal law.
Criminal law, definitely.
Why do you fasten on the criminal law? Your evidence that you have just given is that you would be liable for advice not given in the best interests. You have an express exclusion for any breach of a law. You understand the best interest duty is a statutory provision.
Yes, I do.
It's a requirement imposed by the Corporations Act.
Yes, it is.
And you maintain, do you, that Dover would accept liability for such a breach, notwithstanding the client protection policy?
With respect, we actually have this clause has not been relied on.
Well, Mr McMaster, you're a lawyer. Is your evidence that this clause could be relied on?
It couldn't be relied on now, no.
Why?
It's been withdrawn.
But while it was on foot?
I actually don't know.
You don't know?
No, I don't. Because the genesis is the FOS determination, which basically said we wouldn't have to pay out money if we'd given a notice like that.
And you take legal advice from FOS?
No, we took an idea from what they wrote to us.
I see. Can I take you to page 1133 of that document? Paragraph 4.13. You agree that Dover is not responsible for any losses incurred by you for any reason after 6 months from the date of our most recent statement of advice.
Mm-hmm.
And B, for any reason connected with the misuse of your bank account and investment account details by any person and any failure by any person to keep your account details, passwords, PINs and similar information confidential.
Correct.
And if we go over the page, please. Could 4.16 please be blown up? You are responsible for ensuring our advice to you is implemented on a timely basis, notwithstanding you may have engaged us to implement it for you. You indemnify and release us from any claim for costs or losses connected with any delays in implementing the advice, no matter what caused the delay or who is responsible for the delay. This includes an indemnity and release from any claim connected to an insured event occurring before an insurer has accepted liability under an application for insurance, and any claim connected to asset prices moving before a sale or by instruction or by instruction is implemented.
Yes.
Can I take you to paragraph 8.1 on 1137? Minimum holding period on investments. All investments recommended in your SOA should be held for a minimum holding period of at least 10 years. This is notwithstanding any statement made by the product issuer or any other person in a product disclosure statement or similar document or elsewhere wherein this statement of advice.
Correct.
Could you explain how that clause is intended to work?
Because investments are intended to be held for a long-term period, and what you sometimes have is in the short term, if there's an adverse price movement, everyone goes crazy and starts making claims, not understanding that the whole idea is to invest in the very long term.
By this paragraph, you would seek to exclude Dover from liability for a client acting on an advice that an investment should be held for 2 years, say.
We actually we don't allow advices like that. They have to be for 10 years or more. It's consistent with the structure of the SOAs we create.
You say financial advice is only ever in accordance with the best interest duty if it's a recommendation to hold
Yeah,
for 10
growth
years.
assets, I would be of that view, yes.
Paragraph 8.2. You agree that the performance of the investment will not be known and will not be able to be measured until the end of the minimum holding period, and that no claim or complaint will be made regarding investment performance until the end of the minimum holding period. That's 10 years.
Correct.
Mr McMaster, I put it to you, it is Orwellian to describe this as a client protection policy.
I agree with that.
It is
this, of
entirely
course, has been
misleading, isn't it?
changed. Yeah.
Entirely misleading to call this a client protection policy.
It actually wasn't intended to be misleading. It sort of evolved
Well, I'm asking
without
you,
thought of the word protection.
objectively, do you accept that it was misleading to describe this as a client protection policy?
I think when you look at the totality of the document and what it was trying to achieve, that it actually increased the protection to clients by focusing attention on these issues and ensuring that the client was actively engaged in the process and understanding of the base principles underpinning it.
Is that an honest answer?
Yes, it is actually.
This document is nothing more than an elaborate attempt to exclude Dover's liability for the acts of its authorised representatives. Do you agree with that?
It has an exclusionary effect under the Section 917D, but my concern is that that's a consequence in the situation contemplated by the law.
And what protection does this possibly give to a client?
I agree. That's I agree with that. It's
This
a
is-
misnomer.
This is a Dover protection policy.
Yes, but it also there's other clauses in there you're not looking at which actually increase the liability. For example, we acknowledge damages if there's a breach of the compliance processes. There's about 5 clauses
How
which
could
go
you not?
against
How could you
the
not?
client. There's a lot of others which go very much in favour of the client. There's a huge amount of information brought into the equation.
Mr McMaster, I'm going to put to you that the way you have just described the policy is simply untrue.
Well, I would reject that. But in that rejection, I've certainly understood that, and regretted the use of the word protection. That's obviously been changed.
Do you accept that this document, or at least many aspects of it, were unenforceable?
I think that could be the case now, yes.
How long have you
Well,
thought?
Mr McMaster, does it not then follow that the document itself is misleading or deceptive? Before you answer that, I should perhaps say that if it were misleading or deceptive, that might draw attention to relevant provisions of the ASIC Act about making misleading or deceptive statements.
It's particularly likely to be ineffective in FOS, but we were reasonably comfortable that the actual intent of Section 917D would be looked at, and you're putting it, and we were aware that some of the subclauses could be struck down, but there would be other circumstances where, in certain situations, there wouldn't be a striking down.
And Dover's attitude was to seek the maximum protection it possibly could.
Yes.
And if it turned out that some of the provisions in the contract were unlawful, then so be it, it was worth trying.
I think that's, part of it, yes.
And I'm going to put to you again, this is completely consistent with a culture within Dover that client complaints are to be fought at all cost.
I don't think that's correct.